House Bill 310, an act relating to victims of sex offenses. Representative Heavrin.
Gentleman from McCracken.
Mr. Speaker, I yield to the lady from Grayson for explanation of the bill and motion thereon.
Chair recognizes the lady from Grayson for explanation of bill and a motion thereon.
Mr. Speaker, House Bill 310 does two things. First, it requires notice of the parole board hearings scheduled requirement to the Commonwealth's attorneys from any prisoner convicted of a Class A, B, or C felony to any prisoner convicted for a Class A, B, C, or D felony that is defined as a sex crime under Chapter 17.500. Currently, there is only an opt-in email that you can sign up for. Second, it codifies that a conviction of attempted sexual assault qualifies as a conviction sufficient to allow a victim to obtain an interpersonal protective order. Previously, the perpetrator had to actually complete the assault before the victim could obtain that IPO. Mr. Speaker, I would like to yield to the gentleman from Jefferson 33 for a friendly floor amendment.
Chair recognizes the gentleman from Jefferson 33.
Thank you, Mr. Speaker. We need to suspend the rules to consider House Floor Amendment 3 and 4, 4 being the title amendment. So with that, I would make a motion that we suspend the rules for the purposes of considering floor amendments.
Motion is to suspend the rules for the purpose of allowing the gentleman from Jefferson to call and consider House Floor Amendments 3 and 4. Motion is non-debatable, requires constitutional majority of 51. Those in favor of suspension of the rules vote aye. Those opposed, nay, and the roll call is open for your vote. Clerk will take the roll. In 81 members voting aye, rules are suspended. Gentlemen from Jefferson, House Floor Amendments 3 and 4 are now in order.
Thank you, Mr. Speaker. I would ask the clerk to report House Floor Amendment 3.
Clerk, please report.
House Floor Amendment 3 to House Bill 310.
Gentleman from Jefferson.
Thank you, Mr. Speaker. The underlying bill was a very good one. As amended, it's even better, I think. Here's the problem that we have. There's a man that's about to be released, and this is a problem throughout the Commonwealth, but it's immediate right now in Jefferson County. There's a man that's about to be released, even though he's charged with fracturing the skull of an 18-year-old and then raping her. Of an 8-year-old. He was, did I say 18? I meant 8-year-old. Thank you. Previously, he was charged and released with biting the face of a woman before sexually assaulting her. He has a litany of other crimes in his background. See, the problem is we have a gap. We have a gap where you can be tried and a gap where you can be institutionalized, but there is a gap here that says you're too mentally incompetent to be tried, but not bad enough, or you don't meet the standard to be institutionalized. So these people who are very dangerous are being let out of custody and harming the public. So what this bill seeks to do is address that gap where one can be held, institutionalized, without having to go to trial in very limited circumstances. Now, my libertarian part of me gets really worried about that because I'm thinking, well, you can't institutionalize a person. You shouldn't be able to institutionalize a person if they've not been found guilty. But then on the other side, we have to protect society from folks who committed the crime but who can't stand trial because they can't participate in their defense. So what this bill does is it tries to thread that needle and say, if there's significant proof, and it has to be proven, significant proof that you've committed the crime, but that you can't participate in your defense, so you can't be tried, but that you're a danger to yourself, a significant danger to yourself and to the community, that you can be institutionalized. Now, we've put a lot of protections in there for the hospital, put a lot of protections in there for the guardian ad litem for the individual that has to be appointed and to the defense counsel. And we've said there has to be a periodic review of the case to ensure that this person still remains too mentally incompetent to defend himself, but too dangerous to the community to let free. So that's effectively what the bill does. I want everyone to know that this bill was created by Senator Morgan McGarvey and Senator Julie Rocky Adams, working together with our prosecutors, with our public defenders, with the mental health community, and with circuit judges. And so it is a compromise. It's I think a very good piece of legislation that would address the problem without going too broad, which was a major fear that I had. So I think it threads the needle well. And with that, if there's no questions, Mr. Speaker, I'm going to yield back to the lady from Grayson and allow her to, I think you're going to yield to Jefferson.
Lady from Grayson.
I would like to yield to the lady from Jefferson 38.
Chair recognizes the lady from Jefferson 38.
Thank you, Mr. Speaker. May I speak on the amendment, please?
Yes, ma'am.
Thank you. I want to thank the lady from Grayson, the gentleman from Jefferson 33, the gentleman from Boone, and anybody else I texted last week begging to address this problem. The lady from Grayson and I were sitting here the other night when the news article came through that reminding us that this individual in Jefferson County was going to be out on the streets. And if those of us who live in Jefferson County and have been on social media and been reading the news lately, you know that this is an issue that our constituents are very concerned about. I'll point out a couple of things that the gentleman from Jefferson 33, and I'll sort of fill in from what he said. The Senate bill that he discussed that's from our senators in Jefferson County has been pending since February 10th. It's Senate Bill 239, which is the substance of the floor amendment. The gentleman from Jefferson 33 engaged in extensive conversations with stakeholders from both our mental health community and our court system regarding this amendment. And so people do know, even though we had to suspend the rules to do it, people do know that that it was a possibility of being heard today. And the underlying bill from which it was adopted, Senate Bill 239, has been out there for a while. I wish that we had considered this bill as a standalone on its own, but when you have a situation that happened last week reminding us how urgent this situation is, it was really good for us to adapt and pivot really quickly and be able to address the concerns and protect the public. I want to be really clear, because this did arise out of a court case, that we're not trying to overturn some sort of case or react against some sort of judge or something. This is something that the legal community has recognized as a loophole for some time now. So I want people to know that we're closing a loophole and doing what people have asked us to do instead of doing something that people have not asked us to do. This is a judge in Jefferson County who was following the law, and following the law in this situation has had some really dire consequences. As far as the floor amendment itself, I see it as really a two-step process. Because an individual is going to be accused of committing a crime, there's going to be a finding of guilt or innocence, and then there's going to be that second trigger of the involuntary commitment phase. So I want to be really clear that this has been a joint effort and has been a really good thing that's being responsive to the needs of our community. So I thank you for the opportunity to speak on this and urge passage.
Lady from Grayson.
Mr. Speaker, I would like to move adoption of House Floor Amendment 3.
Motion is for the adoption of House Floor Amendment 3. Is there any discussion? Seeing none, those in favor signify by voting aye. Aye. Those opposed, nay. House Floor Amendment 3 is adopted. Lady from Grayson.
Mr. Speaker, if there are no questions, I would move passage of House Bill 310 as amended by House Floor Amendment 3.
Question before the